What if one sentence on camera could cost a former president everything? Federal courts rarely see surveillance footage, flipped insiders, and a judge threatening arrest all collide in one case. But that's exactly what's happening here. In a single hearing, a story meant to stay hidden exploded into public view, and the fallout could be historic. This isn't rumor, spin, or leaks. This is what the evidence allegedly shows, and it changes everything. Here's the unsettling part. Prosecutors say there's video of a direct order followed by documents disappearing, followed by a witness inside the room breaking their silence. When courts talk about smoking guns, this is what they mean. And when even a judge once seen as sympathetic loses patience, the legal ground shifts fast beneath the defendant, including Donald Trump. So ask yourself this: if the defense collapses on camera, what's left to argue? Stay with us, because the final reason may explain why this moment could be legally irreversible. If you've got a sharp take, drop it in the comments. But don't just react. Tell us which moment changed your mind and why. We put real-time research and effort into breaking these stories down clearly. No fluff, no noise. Subscribe with one click so you don't miss what comes next. Your support keeps this channel going. For decades, powerful defendants have survived serious allegations using one simple shield: plausible deniability. I didn't know. That's not what I meant. Someone else made that call. Those defenses work when evidence is fuzzy, secondhand, or based on interpretation. But everything changes the moment video enters the courtroom. Prosecutors don't have to speculate about intent when a jury can see and hear the order for themselves. There's no guessing tone, no debating memory, no arguing context, away with clever lawyering. This is why video evidence is so devastating. Jurors trust their own eyes more than any argument to a defense attorney can make. When footage allegedly shows a clear time-stamped instruction, the legal battle stops being about narratives and starts being about accountability. Defense teams usually rely on confusion, multiple actors, vague language, layers of separation. Video collapses all of that into a single moment. Who spoke, what was said, and when it happened? That's why prosecutors call it the closest thing to a legal knockout punch. What makes this even more damaging is timing. The alleged order wasn't given years earlier or before legal notice. It came after a subpoena and a preservation order. That timing matters enormously in court. It transforms a questionable act into deliberate defiance. Judges and juries are instructed to look at intent, and nothing signals intent more clearly than acting after being warned. That's why this footage doesn't just support the case, it anchors it. Every other piece of evidence now connects back to that moment. And here's the brutal reality for the defense. Once plausible deniability is gone, every explanation sounds like an excuse. That's why this first point matters more than all the rest. Because when the camera rolls, the defense strategy stops working. And for Donald Trump, that changes everything. Instead of just reacting, tell us this: if you were on the jury, would this video alone change your verdict? Drop your honest take below. We spend hours researching and structuring these breakdowns so you can actually understand what matters and why. If that effort matters to you, subscribe with one click and stay with us as this story unfolds. Even when damaging evidence exists, defense teams often lean on one last escape hatch. You misunderstood what happened? They argue the order was vague, symbolic, or taken out of context. That strategy collapses the moment an insider witness steps forward, especially someone who was in the room, heard the words directly, and then acted on them. This isn't speculation from outsiders. This is someone saying, I know exactly what was meant because I carried it out. Insider testimony is powerful because it fills in what cameras can capture: intent, understanding, and follow through. A video might show an order, but a witness explains how that order was interpreted in real time. Prosecutors don't have to guess whether staff are confused or unsure. The witness confirms they understood the instruction as a command to destroy specific documents. And that understanding is everything in court. If the people receiving the order knew exactly what to do, the defense can later claim it was harmless or metaphorical. What makes this even more damaging is the witness's incentive structure. Testifying under immunity means they are no longer trying to protect anyone. They're trying to protect themselves. Courts and juries know this. Someone who risks public scrutiny and legal exposure doesn't flip lightly. Prosecutors only offer immunity when they believe the testimony is credible, consistent, and corroborated by other evidence. In this case, the testimony allegedly lines up with timestamps, subpoenas, and surveillance footage, forming a tight narrative loop. This combination, video plus insider confirmation, is why juries often say cases feel obvious by the end of trial. The defense can argue memory flaws or political motives, but those arguments sound thin when weighed against someone who was there, did the act. And now explains exactly why, for Donald Trump, this witness doesn't just weaken the defense, it removes its last layer of ambiguity. Once intent is explained from the inside, there's nowhere left to hide. Put yourself in the courtroom. Does insider testimony change how you see the video? Tell us what would matter. Most to you as a juror, these deep dives take serious time and effort to research and simplify without losing accuracy. If you value that work, subscribe with one click and stay with us as we break down what comes next. When prosecutors grant immunity, it's not an act of generosity. It's a strategic signal. Immunity is only offered when prosecutors believe two things are already true. First, that the witness is telling the truth, and second, that the government can prove the case even without them. In other words, immunity isn't taught weakness, it's confidence. Prosecutors don't bet cases on shaky witnesses. They lock the case down first, then use immunity to strengthen what's already solid. From a jury's perspective, immunity actually increases credibility, not decreases it. Why? Because the witness no longer has anything to gain by lying. They're not bargaining for freedom anymore. They already have protection. Their only obligation is to tell the truth. And if they don't, that immunity disappears instantly. So judges make this crystal clear to juries. So when a witness testifies under immunity, jurors hear one message loud and clear: this person is locked in. This is devastating for the defense because it undercuts a common argument. They're just saying this to save themselves. That line doesn't work when the deal is already done. Instead, the focus shifts to consistency. Does the testimony match the documents? Does it match the timeline? Does it match the video? When everything lines up, immunity becomes proof that prosecutors are 3 steps ahead, not scrambling for leverage. Even more damaging is what immunity suggests about the defendant's exposure. Prosecutors don't tome protect minor players unless they believe the real liability sits higher up the chain. Immunity tells jurors this case isn't about a rogue employee or confusion. It's about following orders. And once a jury believes that, the defense loses the ability to shift blame downward. For Donald Trump, immunity testimony doesn't just add evidence. It reveals the prosecution's hand. It shows they're confident, prepared, and convinced the story will hold under cross-examination. In court, that perception alone can tilt the entire trial. Here's the real question: does immunity make a witness more believable to you or less? Tell us your honest answer below. We break these cases down step by step so you can see what actually matters in court, not just the headlines. If that clarity helps you, subscribe with one click and stay ahead as this story keeps unfolding. In court, timing is everything. The same action can be questionable one day and criminal the next, depending entirely on when it happened. That's why this moment is so damaging. The alleged order to destroy documents didn't come before legal notice or during confusion. It came after a subpoena and after a clear preservation order. That single detail transforms the entire case. What might have been argued as carelessness instantly becomes intentional defiance. Judges and juries are trained to focus on intent, and intent is easiest to prove when someone acts after being warned. A preservation order isn't vague, it's explicit. It tells you what must be kept, why it matters, and the consequences of destroying it. When evidence disappears after that point, courts don't ask whether it was wrong. They ask why it was done anyway. And the answer prosecutors offer is simple: to hide damaging facts. This is why defenses built around confusion or misunderstanding collapse under timing scrutiny. You can claim ignorance before a subpoena. You can claim it hours after receiving one. Acting after notice suggests awareness, calculation, and choice. That's exactly what obstruction laws are designed to punish. Not accidents, but conscious decisions to Interfere with justice. Timing turns the act from messy to malicious. What makes this even worse is how jurors emotionally process timing. People instinctively understand deadlines and warnings. If you're told, "Don't touch this," and you touch it anyway, the story becomes personal. Jurors don't need legal training to grasp that. They see it as disrespect, not just toward the law, but toward the court itself. That's why judges react so strongly to post-notice violations. For Donald Trump, the timing doesn't just strengthen the prosecution's argument, it locks it in. It gives the court a clean narrative: warned, ordered to preserve, and then chose to destroy. Once that sequence is established, intent is no longer a question, it's the conclusion. Let us know this. Does timing alone convince you someone meant to obstruct justice? Drop your take. We read every serious comment. These breakdowns take real research and careful structure, not just reactions. If you value that effort, subscribe with one click and stay with us as the case escalates. One of the clearest signals in any courtroom isn't what the lawyers say, it's how the judge reacts. Judges are trained to be controlled, cautious, and restrained, especially in high-profile cases. So when a judge's tone shifts from patient to furious, it sends a powerful message to everyone watching. It means the issue is no longer procedural. It's personal to the court. And once a judge feels the authority of the court has been challenged, the legal stakes skyrocket. Judges see excuses all day long. They hear claims of confusion, delay, and misunderstanding constantly. But there is one thing that reliably triggers a strong response: evidence, destruction after a direct order. The courts view that as an attack on the justice system itself. It's not just about one case anymore. It's about whether court orders mean anything at all. That's why judges react sharply, sometimes explosively, when preservation orders are violated. What makes this moment especially damaging is that the judge involved had previously been seen as measured and cautious. When even a restrained judge signals that conduct may warrant criminal contempt, it tells the defense something critical. The margin for leniency is gone. Judges don't threaten custody lightly. They do it when they believe compliance has failed and authority must be enforced. From a jury's perspective, judicial reaction matters more than people realize. Jurors take cues from the bench when they sense that a judge views conduct as egregious. They subconsciously recalibrate how serious the behavior must be. That doesn't mean the judge is biased. It means the facts are strong enough to trigger a response, even through professional restraint. For Donald Trump, this shift is devastating. A judge who once gave the benefit of the doubt, now signaling zero tolerance, changes the entire landscape. It tells the defense the court is done negotiating, and when that happens, consequences move fast. The case is no longer drifting, it's accelerating. Here's the real test. When a judge loses patience, does that change how you see the case? Tell us your honest view below. We take the time to analyze courtroom dynamics, not just headlines, so you get the full picture. If that depth matters to you, subscribe with one click and stay with us as this story unfolds. Courts don't impose daily fines to punish the past. They do it to force action in the present. That's what makes these penalties so dangerous. A one-time fine can be absorbed, delayed, or appealed, but daily accruing fines create pressure that never stops. Every sunrise adds another massive hit. It's not symbolic. It's mechanical, relentless, and designed to break resistance. Judges use this tool when they believe a defendant is choosing not to comply, not struggling to do so. The psychology behind daily fines is simple and brutal. They shift the question from will you comply to how long can you afford not to. Each day of delay becomes a conscious, measurable decision. Jurors and judges understand this instinctively. When someone continues to defy orders while penalties pile up, it looks less like confusion and more like arrogance, less like delay and more like defiance. Financial pressure also weakens legal strategy. Resources that would normally fund appeals, experts, and delay tactics are drained day by day. Compliance becomes cheaper than resistance, but only if it happens early. Once fines reach millions, every argument sounds hollow. Courts interpret prolonged noncompliance as proof that only coercion, not persuasion, will work. What's especially damaging is how daily fines interact with other penalties. It doesn't replace judgments or charges. They stack on top of them. That means, Financial exposure grows in multiple directions at once. Judges know this, and that's why daily fines are often paired with explicit warnings about custody. It's the court saying, money first, freedom next. For Donald Trump, daily fines transform the case from a legal battle into a countdown. Each day without compliance strengthens the court's hand and weakens the defense's credibility. At some point, the question stops being if consequences escalate and becomes when be honest. At what point do daily fines stop looking like pressure and start looking like proof of defiance? Share your line in the comments. We put real effort into breaking down how courts actually apply leverage, not just what makes headlines. If that clarity helps you, subscribe with one click and stay with us as the stakes keep rising. In isolation, almost anything can be explained away. A single bad decision can be blamed on stress, confusion, or poor advice. That's why defense teams fight so hard to keep cases narrow and siloed. But once prosecutors establish a pattern of behavior, everything changes. Courts and juries are allowed to look beyond one incident and ask a much bigger question. Is this how this person operates when under pressure? Pattern evidence is powerful because it removes coincidence from the equation. When the same behaviors repeat, misrepresentation, denial, delay, and then attempts to hide or destroy evidence, it stops looking accidental. It starts looking intentional. Prosecutors use patterns to show state of mind, which is one of the hardest things to prove. In any case, you don't need to read someone's thoughts when their actions keep following the same script. This is especially damaging because patterns make alternative explanations collapse. The defense can no longer argue this was different or this situation was unique. When jurors see the same response across multiple legal threats, instead, jurors begin to anticipate the behavior before it's even described. That anticipation is deadly for credibility. Once a jury believes they know what's coming next, the defense has already lost control of the narrative. Judges also pay close attention to patterns. Courts are far less patient when they believe they're being tested or manipulated. A pattern suggests not just non-compliance, but disrespect for court authority. And when that belief takes hold, judges escalate faster, impose harsher remedies, and stop giving the benefit of the doubt. For Donald Trump, pattern evidence doesn't just add weight. It locks the door on innocent explanations. It tells the court, this isn't about one bad call or one misunderstood order. It's about a consistent response when accountability approaches. And once a pattern is established, juries don't ask whether the behavior fits. They assume it does. Let us know this. When you see the same behavior repeat, does it stop being a mistake for you? Drop your take below. These breakdowns take serious time and careful analysis to connect the dots clearly. If that work matters to you, subscribe with one click and stay with us as this case keeps unfolding. Legal battles don't happen in a vacuum. High-profile cases are fought on two fronts at the same time, inside the courtroom and in the public narrative. When those narratives stay aligned, defendants gain breathing room. But when media allies fracture, confusion replaces coordination, and that confusion spills directly into legal risk. Mixed messaging doesn't just look messy, it signals vulnerability. Here's why this matters. Defense teams rely on consistency. If public explanations change day to day, jurors start to wonder which version is closest to the truth. Contradictions don't have to come from the defendant themselves. They can come from supporters, commentators, and friendly outlets trying to explain the same facts in different ways. Each inconsistency becomes a crack prosecutors can pry open, asking jurors to notice how the story keeps shifting as new evidence appears. Media fracture also undermines credibility with judges. Courts are aware of public messaging, especially in cases this visible. When coverage becomes hesitant, defensive, or conflicted, it reinforces the perception that the evidence is difficult to explain away cleanly. Silence can be just as damaging as spin if outlets hesitate to defend conduct outright. Jurors interpret that hesitation as doubt, even among allies. What makes this especially dangerous is how it feeds back into the legal process. Jurors don't enter courtrooms as blank slates. They bring impressions shaped by what they've seen and heard. When those impressions are chaotic rather than confident, the defense starts from a weaker position. The prosecution doesn't need to argue credibility. They let the confusion do that work for them. For Donald Trump, fractured media response magnifies every other problem in the case. Video evidence looks worse. Witness testimony sounds stronger. Judicial reactions feel more justified. When even supportive voices struggle to stay on message, the illusion of control disappears. And once control is gone, momentum belongs to the prosecution. Quick check. When defenders cannot agree on the story, does that change how believable it feels to you? Share your honest take below. We spend real time connecting legal facts with real-world impact, not just repeating headlines. If that perspective helps, subscribe with one click and stay with us as this case accelerates. Up to this point, much of the damage has lived in the civil world. Money, assets, penalties, and judgments. Painful, yes, but survivable with time, appeals, and delay. Obstruction of justice is different. The moment prosecutors move toward obstruction, the entire case crosses a line. It's no longer about finances or paperwork. It's about criminal intent and interfering with the justice system itself. The courts treat obstruction as one of the most serious offenses because it strikes at the heart of the legal process. Fraud harms victims. Obstruction harms the rule of law. That's why prosecutors pursue it aggressively and why judges respond so sharply when evidence supports it. Destroying or directing the destruction of subpoenaed materials isn't a side issue. It's a separate crime with its own penalties, including potential jail time. And crucially, obstruction charges don't require proving the underlying case was wrong, only that someone tried to block the truth from coming out. From a defense standpoint, obstruction is a nightmare. It narrows the field of arguments dramatically. You can debate valuations, contracts, or intent in a fraud case. Obstruction cases are simpler. Jurors are asked one basic question: did the defendant knowingly interfere with evidence after being told not to? Video, timestamps, court orders, and witness testimony are tailor-made for answering that question clearly. Even worse, obstruction charges have a compounding effect. Once they're in play, judges are more willing to impose harsh sanctions, deny leniency, and accelerate enforcement. It also poisons the well for every other defense. Juries start to assume that if someone tried to hide evidence, there must have been something worth hiding. That assumption is devastating. For Donald Trump, obstruction doesn't just add risk, it redefines the case. It shifts the spotlight from disputed facts to deliberate conduct. And once a case becomes about obstruction, outcomes tend to move fast and rarely in the defendant's favor. Let's hear it. Does trying to block evidence matter more to you than the original accusation itself? Tell us where you draw that line. We put serious effort into explaining why legal shifts like this are so consequential, not just dramatic. If that dip matters to you, subscribe with one click and stay with us as this story reaches its most critical phase. There's a reason legal experts repeat the same warning over and over. The cover-up is often worse than the crime. Courts can debate intent, numbers, and interpretations in an underlying case. But once someone is caught trying to hide, destroy, or manipulate evidence, that debate ends. The focus shifts from what happened to why someone tried to stop the truth from coming out, and that shift is devastating. Judges are allowed to draw adverse inferences when evidence is destroyed after a preservation order. That means the court can legally assume the missing documents would have been harmful to the defense. In other words, destroying evidence doesn't tonic, erase it. It reappears as the worst possible version of itself in the judge's reasoning. What might have been disputed facts suddenly become assumed conclusions. This is where everything accelerates. Courts lose patience quickly once they believe they're being misled. Leniency disappears. Deadlines tighten. Sanctions increase. What began as a fight over documents turns into a fight over respect for the court itself. And when judges feel the integrity of the process is threatened, they respond forcefully, not emotionally, but institutionally. From a jury's perspective, the logic is simple and deeply human. If the evidence helped you, why destroy it? That question hangs over the entire trial. No explanation sounds satisfying once that doubt sets in. Even unrelated defenses start to feel untrustworthy. Credibility once lost doesn't come back. For Donald Trump, this final point may be the most dangerous of all. Whatever the outcome of the original allegations, the attempt to control or erase evidence reshapes the entire legal narrative. It transforms a complex case into a straightforward one about obstruction, accountability, and consequences. And history shows that when cases reach this stage, the ending is rarely favorable. Be real with us. Does destroying evidence automatically make you assume the worst? Tell us how you see it in the comments. We invest real time, research, and structure to explain why moments like this matter so much. If that effort means something to you, subscribe with one click and stay with us for what comes.